ICOs are becoming a very interesting mechanism to raise capital for your startup. So here, we're going to talk about its regulation in Mexico. First of all, let me start by saying that even though we do not have specific statistics about how many ICOs we have had in our country, we do have a vibrant crypto community. It is very common to hear about entrepreneurs who are building exciting tokens and who are planning to launching them in the Mexican market. This frenzy has been contagious also to international companies who are willing to launch their own tokens in the Mexican market as well. This is why I believe that the ICO market and the ICO scene in Mexico will become very big in the next couple of years. So this takes me to the next big question, which is, what is the regulation in Mexico? So let me tell you that we have a complex regulation for ICOs. And the regulation that you will be subject to depends on the type of token that you are launching into the market. We already know that not all tokens are created equal, and Mexican law will regulate the three types of tokens. First, cryptocurrencies, which under the law are considered virtual assets, regulated by the recently enacted federal law to regulate technology financial institutions. Under this new law, technology financial institutions are not allowed to operate with virtual assets who have not been approved by the Bank of Mexico. This is very important because if you are creating a token that is meant to be a payment system and that is meant to be used by the general public as a mean to pay for obligations or for services or for goods, then you will need first to get that token authorized by Bank of Mexico. If you fail to do so, no technology financial institutions, such as exchanges, will be able to carry your token and sell it in Mexican markets to the general public. The second type of token that's regulated under Mexican law are tokenized securities, which are regulated by the Mexican securities market law, which basically defines securities as a certificate representing capital on a corporation or business entity, or a certificate representing ownership of a specific good, or a certificate representing any kind of debt. So if your token has some of these three characteristics, it could be considered a security under Mexican law. Our law in our securities regulation establishes that you cannot sell securities to the general public unless you have the authorization of the National Securities and Banking Commission and unless such securities are registered in the National Security Registry. There are several exceptions to this general rule, but the three most notable exceptions related to ICOs are offerings made to institutional or qualified investors, offerings made to less than 100 people in case of securities that represent capital of a corporation or business entity, and a newly enacted exception, which is the crowdfunding rule. So in a way, if you develop a tokenized security, you can either offer it to institutional or qualified investors, offer it to less than 100 people if your token represents capital of a corporation or business entity, or you can also place it within a crowdfunding platform company. The third type of token that's regulated under Mexican law are simple tokens, or what's been called in the worldwide crypto community as utility tokens, which are basically goods by themselves. They are regulated basically by consumer protection laws as any other good or service that you would provide in the Mexican market or within the Mexican jurisdiction. Finally, it is important to consider the standpoint of the Mexican government towards ICOs. Mexican government is quite observing about them. They are studying about what's happening in Mexico and in the world, and they, even though they are not willing to prohibit such transactions, it is important to note that they are very interested in protecting the general public who are participating as buyers of these token offerings. It is my guess or my opinion that the Mexican government will move towards the protection of the general consumer market of people buying ICOs, and they will issue important regulation in the following months and years to try to prevent schemes and scams happening within the Mexican jurisdiction. To conclude, it is important to note that Mexican law regarding ICOs is complex, and the regulations that you should be subject to will depend on a large scale on the type of token that you are issuing. It is always advisable to consult with competent attorneys or consultants that would help you determine which type of token under Mexican law you are offering, so that you are 100% knowable about what are the legal implications of your transaction.